various acts which are brought out by the legislature, the distinction will have to be appreciated and it has to be applied when cases come before court. The Supreme Court, the National Commission, the state commissions have all interpreted the provisions of the Act in various ways. The problem that an Act encounters as soon as it is passed is that the meaning will have to depend upon the context of various situations. And it is quite impossible for the legislature to conceive where this Act will be applied in various situations at the time when the Act is passed. Now, that is the problem. So the legislature cannot, however imaginative the legislature is, it really cannot actually visualize the several instances to which this Act will apply. This is why the power of interpretation has been granted to courts, because the Consumer Protection Act has existed for a good 30 years and more in the statute books. There has been a lot of interpretation that has been applied. But the problem that members of the District Consumer Forum will face is that because there is no been an amendment in 2019, how are we to read the provisions of the Act along with what happened in terms of interpretation of the provisions of the Act earlier, right? So this is going to be the real challenge for persons who are heading the various district forums. You have to now understand the provisions of the Act, and you will, because this 2019 Act, what it seeks to do is, it is a wholesale amendment, because it is brought in a fresh Act in substitution of the earlier existing Acts. Therefore, the problem becomes a little more acute whenever words are called upon to be interpreted, whenever words are called upon to be applied. You will have to once again read the definition, compare it with the words that existed earlier, note the changes that have been made, make note of what the changes will imply, assess what the application of these changes is to the fact situation before you. All this will have to be considered when you embark on the process of interpreting the provisions of the Act. That is why this session is supposed to provide some sort of a guidelines to help you to do that. As I said, I am still dealing with the main framework in which this exercise of interpretation will be done. Now, let us look at some of the basic rules of interpretation. Of course, the persons who head the district forum have judicial training, and therefore it may pose lesser challenges to them in interpreting the provisions of the Act. But the other members of the forum will have to also understand that there are things called rules that are applicable to interpretation of statutes, and they will also have to be aware of these nuances in interpretation of the statute when they proceed to interpret the provisions of the consumer. Now, let us look at some of the interpretation of statute itself, a huge subject, right? The most classic work on this is a book called Interpretation of Statutes by a very renowned judge, Justice G.P. Singh. He is no more. But that book ranks along with Searway's Constitution of India. It's a classic work on the principle to be applied in the job of interpretation, right? So I would request, but it is a very, very technical work. So I do not know how much the members of the district forum would find it interesting. Therefore, my attempt here is to actually state some of the commonly used principles in statutory interpretation and then leave it to the larger body to decide how these provisions, how these principles can be applied to give greater benefit.
Hello?
So there's an interruption.
Yeah. Please mute your mics.
Can you hear me now?
Yes, sir. It's better now. Yeah. Thank you.
Yeah. Right. So now let us look at some of the very, very elementary principles. As I said, general interpretation of the statutes. What I am going to do in this session is going to tell you what the larger general principles of statutory interpretation are and illustrate that by reference to a few cases where the Supreme Court and the National Commission have had occasion to deal with these provisions, right? So the first very common rule in statutory interpretation is what is called the literal or grammatical interpretation. The first rule of interpretation is what is called the literal or general rule of interpretation. And it says the words of a statute are first understood in the natural and ordinary meaning. First, try to understand the words in the very natural and ordinary meaning, right? It is only if the natural and ordinary meaning is incapable of comprehension that you need to go into this exercise of interpretation at all. So the first attempt is please understand the words in their clear meaning. In Saraswati Sugar Mills versus Haryana State Board, the Supreme Court held, for example, I'm just giving you this example, that the word is vegetable in entry 15 of Schedule 1 of the Water Prevention and Control of Pollution is to be understood as common parlance. Botanical meaning cannot be given to the word. So it said, when a word is to be used in trade and commerce, and if a question is, what does the word mean in the ordinary parlance of trade and commerce, don't go into a larger botanical word meaning because that may include a larger class of species. But the purpose of the law is to only make it applicable to trade and commerce, and you will have to understand that word in the context that it is used in trade and commerce. So this is one classic example of how the literal or grammatical interpretation has to be applied. The second important rule is what is called the mischief. What is this mischief rule? The mischief rule is also known as the purposive construction. That is, whenever a law comes into force, the purpose of that law is to address a problem. Why is a law brought out? Much of law is brought out to address a problem. Leave alone what are called fiscal statutes. The purpose of fiscal statute is to ensure better revenue to the government. Leave that class of statutes also. Generally, what is the purpose of law? The purpose of law is to address a human problem, right? So when the question is, so first you are not able to create it on the basis of the literal or grammatical interpretation. There is some ambiguity in the provision, and you need to address that ambiguity You need to clear the fog. You need to understand the statute better. Then the rules of interpretation advise that go to the next rule, which is called the mischief. In the mischief rule, what do you do actually? You ask three questions. These three questions are: what was the law before this provision came into existence?
Mr. Sorry to interrupt. Sorry to interrupt, but there is a comment that your voice is very low and not audible.
Okay, let me try and speak into the mic possibly. Now, can you hear? Just give me a minute. Just give me a minute.
Yes, please.
Yeah, I am now trying to speak into the mic. Am I better now?
Yes, to me it's much better. I would like to hear from the others.
Am I better now?
Very better it is.
Yeah, as I go along, if somebody has a problem, do let me know.
Yeah. Yeah, should be fine.
So, there are four questions that you need to ask when you apply the mischief rule. What was the law before making of the act? What was the reason behind making of the law? Or what was the mischief or defect which the law did not provide for earlier? What is the remedy which the act has provided? What is the reason for the remedy? The rule then detects the defects and enhances the law for providing the remedy. முன்னாடி இருக்கிற ஏதோ ஒரு தப்ப சரி செய்வதற்காக கொண்டு வந்த ஒரு சட்டம். ஏன் முன்னாடி இந்த ப்ரொவிஷன்ஸ் எல்லாம் இந்த ஆக்ட்ல இருந்தது. அந்த ப்ரொவிஷன்ஸை வச்சு இந்த ஆக்ட் அப்ளை பண்ண பார்த்தாங்க. பட் அந்த ப்ரொவிஷன்ஸ் மூலியமா இந்த ஆக்ட் என்ன பண்ணணும்னு நினைக்கிறதோ அதை இஃபெக்டிவா பண்ண முடியல. அதுக்காக சில மாற்றங்கள் கொண்டு வந்து இதை மாற்றினார்கள். அப்படிங்கறத we have to understand. இது once again in the 2019 act, this rule is going to be very useful for you because it will help you to understand some of the provisions. For example, consumer definitionல இல்ல defectsங்கிற definitionல deficiency in serviceங்கிற definitionல சில குறைபாடுகள் இருந்திருக்கலாம். அந்த குறைபாடுகளை களைவதற்காக இந்த mischief rule நீங்க யூஸ் பண்ணலாம், இன்டர்பிரேட் பண்ணலாம். இந்த மாதிரி சட்டம் முன்னாடி இருந்தது. இந்த முன்னாடி இருந்த சட்டம் வந்து it was not very effective. இதை மாற்றுவதற்காக இப்படி ஒரு மாற்றம் கொண்டு வந்திருக்கப்பட்டிருக்கிறது. அதனால நீங்க முன்னாடி இருந்த சட்டத்தின் கீழே கொடுக்கப்பட்டிருக்கிற ஒரு கேஸ் லாவை சைட்னா இப்போ ஒத்துக்க முடியாது அப்படிங்கிற ஒரு நிலைமைக்கு நீங்க கொண்டு வரலாம். ரைட்? அதை உங்களுக்கு இன்டர்பிரேட் பண்றதுக்காக தான் இந்த mischief rule is being provided. There is a third rule which is called the golden rule. It slightly modifies the literal or grammatical rule of interpretation. Ordinarily, the court must follow the true meaning of the word or law given in the statute. But when such words used in a statute by the natural or ordinary meanings leads to injustice or evasion, then the court must modify the meaning of that word to that extent that it must not cause injustice. உங்களுக்கு ஒரு சின்ன எக்ஸாம்பிள், லீ vs ஸ்னாப் அப்படின்னு ஒரு பிரிட்டிஷ் கேஸ். அதுல என்னன்னா interpretation of the word stop was involved. Under section 77(1) of the Road Traffic Act 1960, a driver causing accident shall stop after the accident. ஒரு ஆக்சிடென்ட் நடந்ததுக்கு அப்புறம் இந்த காரை எடுத்துட்டு போற ஒரு டிரைவர் உடனே இந்த காரை நிறுத்த வேண்டும். இந்த கேஸ்ல என்ன பண்ணாருன்னா, the driver stopped for a moment after causing an accident and then moved away. He just stopped for a moment. The wordings in the act is you must stop the car. He stopped the car for just a minute. The question was whether the driver had broken the law. Applying the golden rule of construction, the court said that the provision of the act had not been followed because it is just not stop means just stop for a minute. You have to stop, full stop, and allow the law enforcers to do what they have to do. So you can't, by a clever argument, say the law requires me to stop. I stop for a minute and then I proceeded. The requirements of the stop are not met. That is why the golden rule comes into operation to help to, is ரொம்ப important, to further the objects of the act. அதாவது நீங்க போற பாதையில ஒரு 2 ஆப்ஷன்ஸ் உங்களுக்கு இருந்தா, ஈவன் 3 ஆப்ஷன் உங்களுக்கு இருந்தா, நீங்க என்ன பண்ணணும்னா, எந்த இன்டர்பிரேஷன் ஃபேவர்ஸ் the manner in which the law can be more effective, that interpretation you should. So this is the most important point in interpreting any law. நீங்க போற interpretation of a statute, when you face a problem, you must apply that meaning. 3 meaning எடுத்துக்கங்க. You take all the 3 meanings and ask yourself the question, இத எந்த மீனிங் நான் அப்ளை பண்ணா the provisions and the object of the Consumer Protection Act is satisfied better? That is the question you have to ask. And you have to apply that meaning which promotes the objects of the act, subject to other qualifications. See, you cannot do violence to the language of other sections. அதுக்குதான் நம்ம அடுத்த rule of interpretation வரும். The next rule of interpretation is what is called harmonious construction. Now you can ask, sir, is a golden rule நீங்க சொல்லிட்டீங்க, I have 3 or 4 options before me. Can I on my own proceed and interpret the provisions of the act in such a way that it helps the consumer even though it departs from the object of the Consumer Protection Act? இப்போ ஒரு சின்ன உதாரணத்துக்கு எடுக்க, உங்களுக்கு I think many of you have this what is the purpose of the Consumer Protection Act? The purpose of the Consumer Protection Act is to favor the consumer, right? So let us take a case where a sovereign duty is involved. Okay, for example, stamp duty, stamp registration act. இப்போ வந்து ஹை கோர்ட் நிறைய கேஸ்ல என்ன சொல்றாங்கன்னா, நீங்க இப்போ document is presented for registration and proper stamp duty is not paid, the law is very clear that the assessing stamp duty authority must only put a chapa and say balance stamp duty has to be collected after determination and return the document to the person who is presenting the document for registration. அப்படிங்கிற இது சட்டம், சரியா? இப்போ and then what should the authority do? The authority should then pass on the document to the collector. The collector has certain duties to perform under the provisions of the Registration Act, the Stamp Act. He must determine passes. But the stamp duty itself has to be returned back to the person who is presenting it with the seal that this document is pending. In the case நீங்க எடுத்துக்க, suppose a consumer comes to a consumer court and says, ஒரு கேஸ்ல வந்து அவர் திருப்பி கொடுக்கல, அந்த டாக்குமெண்ட்டை நான் திருப்பி கொடுக்க மாட்டேன், நீங்க எனக்கு ஃபுல் ஸ்டாம்ப் டியூட்டி கொடுத்தாதான் நான் கொடுப்பேன் அப்படின்னு சொல்லி ஒரு stamp registering authority வந்து வாங்கி வச்சுக்கிறாங்க. What would be the situation? The consumer will come to court and say that I am a consumer. Yeah, because the registering authorities are rendering service to me. I have paid consideration. What should I do? I should pay consideration. Consideration நான் பே பண்ணியாச்சு. இது நான் வாங்குறது வந்து ஒரு வீடு. வீடு வந்து is not commercial purpose. So I am not barred by the provisions of the Consumer Act. So pass an order asking him to return the document to me and ask him to pay compensation. இப்படி ஒரு கேஸ் வந்ததுன்னா If you apply the mischief rule, if you apply the golden rule, then you have to grant the relief naturally. Ana, there is something called the harmonious construction. When you consider the harmonious construction, it is very clear that relief can be granted only in respect of non-sovereign functions. இப்போ நீங்க கேட்கலாம், எங்க இருக்கு இந்த கன்சூமர் ப்ரொடெக்ஷன் ஆக்ட்ல நான்-sovereign functionsக்கு தான் நான் கொடுக்கணும்னு சொல்லி எங்க இருக்கு? Now that becomes a subject matter of interpretation. So therefore, where a certain types of duties can only be done by a sovereign state, right? Then that is called a sovereign function. But இதுலயே ஒரு distinction, which is what the Supreme Court held in the Lucknow Development Authority. If the government takes on certain businesses which are actually in the realm of the common commercial stream, Lucknow Development Authority versus M.K. Gupta என்ன issue? The government took on the job of developing plots, putting up construction, இதெல்லாம் பண்ண ஆரம்பிச்சாங்க. Now there were certain defects and deficiencies in the manner in which it was carried out. The matter went to the lower fora. The lower fora held that they are guilty of deficiency itself. The matter went up till the Supreme Court. Supreme Court said that there is a distinction. The argument taken was, idella sovereign functions. In taking up the development work, I am taking up the development work under the provisions of a statute. Therefore, these functions are all excluded from the provisions of the Consumer Protection. This argument was shot down by the Supreme Court, and the Supreme Court said, where the state is stepping into the realm of a commercial activity and is carrying on that commercial activity, then the principles of statute, interpretation of statute will not help the state in saying that these are accepted functions. எப்படி நீங்க சொல்ல முடியாது? ஏன்னா this is an order, this any, அதாவது இந்த ரெண்டு கேஸ்லயுமே distinctions பாருங்க. Can I as an individual tomorrow start a document registration office? I can't. Like, it's only the government which can discharge the functions of a document registering authority, assessing stamp duty, collecting stamp duty, registering a document, issuing an encumbrance certificate. நாளைக்கு நான் போர்டு போட்டுட்டு I can't say that I take on document, register documents and issue encumbrance certificate. That I can't do. Only the government can do. On the other hand, any private party can take on the job of developing plots, developing buildings, putting up construction, handing over possession, collecting charges. Any person can do. Any common man can do. Therefore, the distinction has to be borne in mind. This sovereign function argument will not help. That is because of the application of the principle of harmonious construction. The basis of the harmonious construction is the legislature must not have intended to contradict itself. Right? One perfect example is the case of Ishwari Ketan Sugar Mill in the state of UP. The state government proposed to acquire sugar industries into the state under the Uttar Pradesh Sugar Undertakings Act. So this was challenged on the ground that sugar industry has been declared a control industry by the union under the Industries Development and Legislation Act. And therefore, the state did not have the power of acquisition or requisition of the property with respect to the declared controlled industry. And Supreme Court adala enna sonnanga, that the field of acquisition is not accepted by the industries, and the state power to acquire was an independent power. So they had to read it harmoniously to come to this conclusion. So this is again an illustration of the harmonious construction rules. A subsection of this harmonious construction rule is you need to read the statute as a whole, right? This is a subspecies of the harmonious construction. In Bhavnagar University versus Palitana Sugar Mills Private Limited, the Supreme Court observed that it is a basic principle of construction of statute that the same should be read as a whole, then chapter by chapter, section by section, and word by word. This is the order which the Supreme Court has recommended. Therefore, first, the act itself is to be read as a whole, then chapter by chapter, section by section, word by word. Recourse to construction or interpretation of statute is necessary when there is ambiguity, obscurity, inconsistency therein, and not other than. Supreme Court in the case when சொல்றாங்கன்னா நீங்க எல்லாத்துக்கும் போய் interpretation of statute போவாதீங்க. First, check and see whether the acts are plain and the plain meaning of the act can be given effect to. அதை நீங்க முதல்ல பண்ணுங்க. It is only where there is an ambiguity that you can invoke the other provisions of the act. This is what the Supreme Court says. So these, as I said, the principles that are to be applied in interpretation of statutes, there are any number of principles. Each have arisen from a necessity to make the act more meaningful. But when it comes to the question of the Consumer Protection Act, what are the words that have caused problems for the judicial fora? Right? Now, அதெல்லாம் கொஞ்சம் list பண்றேன். Please see what they are. First, who is a consumer? So this has caused a great amount of problem. I'll come to the cases where they have been interpreted and how they have been interpreted. So the first problem you have to encounter, and you will be called on to encounter, is who is a consumer. The second is the word goods. What are goods? Right? எதெல்லாம் what can be classified as goods? மூணாவது what is a service? Right? So the question, these three questions are the recurring questions in the interpretation of the Consumer Protection Act. Who is a consumer? What is a consumer dispute? The definition of the term consumer dispute. Who is a complainant? What is defect in goods? What are deficiencies in services? What is a commercial purpose? இந்த வார்த்தைகள் தான் திருப்பி have been taken up for consideration, and sometimes the Supreme Court has also been very interpretative, imaginative, and purposive in interpreting these provisions and giving meaning to these. So நீங்க இந்த வார்த்தைகள் தான் உங்களுக்கு பிரச்சனையை தரக்கூடிய சொற்கள். இந்த சட்டத்தின் கீழ் பிரச்சனைகளை தரக்கூடிய சொற்கள் இதுதான். The interpretation of these statutes forms a bulk of the problems with regard to who is a consumer. இப்ப நீங்க you will also have to read it. இப்ப இந்த வார்த்தையை நான் எப்படி இதற்கு நான் அர்த்தம் கொடுக்கிறது அப்படின்னு நீங்க எடுத்துட்டீங்கன்னா, you first have to understand the main frame of the Consumer Protection Act. இப்ப புதுசா வந்திருக்கிற Consumer Protection Act it has actually widened the definition of a consumer, which includes offline and online transactions through electronic means, or by teleshopping, or direct selling, or multi-level marketing. நீங்க என்ன புரிஞ்சுக்கணும்னா, டெக்னாலஜி வளர வளர எப்படி வணிகம் வளரும் என்பதும் மாறிக்கொண்டே வருகிறது இல்லையா? டெக்னாலஜி இஸ் நாட் த சேம். டுடே இன்னைக்கு உங்களுக்கு சாப்பாடு வேணும்னா ஸ்விக்கியில் ஆர்டர் பண்ணா 2 நிமிஷத்துல வந்துடுது. நீங்க வீட்டுல சமைச்சு உங்க பையனுக்கு அவனோட ஆபீஸ்ல டெலிவர் பண்ணோம்னா டன்சோட்ல சொன்னா அவங்க கொண்டு போய் டெலிவர் பண்ணிடுவாங்க. ரைட்? ஸோ these are not things that existed. இனிமேலாம் ட்ரோன் டெலிவரி வரப்போகுது. You will have your food delivered through drones. You will have medicines delivered through drones. The 5G spectrum, there are going to be so many facilities that are going to be done. The Contract Act frame பண்ணும்போது, none of this was in the minds of the framers. When was the Contract Act framed? The Indian Contract Act came into existence in 1872. Right? 150 வருஷம் முடிஞ்சது Indian Contract Act வந்து. ஆனா இந்த 150 வருஷத்துல எப்படி contracts are finalizedங்கிற method have changed drastically. It is not the way in which it was done 150 years back. 150 years back, யாராவது ஒரு இமெயில்ல ஒரு ஆஃபர் அக்செப்டன்ஸ் ஃபண்டமெண்டல்ஸ் ஆஃப் கான்ட்ராக்ட் இல்லையா, ஆஃபர் அக்செப்டன்ஸ் கன்சிடரேஷன் ஃபண்டமெண்டல்ஸ் ஆஃப் கான்ட்ராக்ட், ரைட்? 150 years back, none of us would have contemplated, or the lawmakers would not have contemplated, that you can make an offer by email. The acceptance of the offer can be by email. The consideration for the payment can be done through a bank transfer or a GPay. இதெல்லாம் அவங்க நினைச்சே பார்த்துக்க முடியாது இல்லையா? All these things were not existing 150 years back. All that has today come into existence. All those facilities have come into existence. But our Indian Contract Act remains the same. So you today have to interpret the provisions of the Act to address these realities which have come into existence. Ilya, I will not recognize an acceptance which has come by email because that is not contemplated under the Contract Act 1872. நம்ம சொல்ல முடியாது. Therefore, we must commend the Consumer Protection Act, which for the first time recognizes that the definition of a consumer will include offline and online transaction through electronic means, or by teleshopping, or direct selling, or multi-level marketing. So for the first time, all these have been brought within the provisions of the Act. America ஒரு interesting case நடந்தது. அவன் என்ன பண்ணா, இந்த ஆன்லைன் ஷாப்பிங்ல அவனோட வீட்டோட படத்தை போட்டு அதுக்கு கீழே he gave a caption, all this yours for $10,000 அப்படின்னு போட்டான். Right? So this was sold in eBay. eBayங்கிறது as you know is a platform. eBayலாம் என்ன, அந்த காலத்துல கிராமத்துல இருந்த சந்தையில என்ன பண்ணுவாங்க, சந்தையை நடத்தும் பஞ்சாயத்துக்கு சந்தையில விற்கும் பொருள் தரமானதா தரம் இல்லாததா அப்படிங்கிறதுக்கு ஒரு they don't give any warranty. ஒரு சந்தையில வந்து ஒரு மாடை வாங்கிட்டு போனான்னா the சந்தை does not give a warranty that the cow that is purchased in the சந்தை is of good quality னு கொடுக்கிறது. eBay இந்த பிளாட்ஃபார்ம்ஸ், Flipkart, eBay, Amazon, இதெல்லாம் வந்து இன்னைக்கு இருக்கிற எலக்ட்ரானிக் சந்தை. அந்த சந்தையில வந்து இந்த ப்ராடக்ட்ஸ் எல்லாம் விற்கிறாங்க. Alright? So eBayல இந்த மாதிரி ஒரு ப்ராடக்ட் was brought for sale. என்ன, there is a picture of a nice house, அதுக்கு கீழே all this yours for $10,000. Some consumer thought that if he paid $10,000 he will get this excellent house. அவன் $10,000 அனுப்பிச்சான். அனுப்பிச்சவனுக்கு என்ன கிடைச்சது, அந்த picture of the house அனுப்பிச்சிட்டான். The picture of the house which was there in the eBay was sent, and the argument was the offer said all this for $10,000 yours for $10,000. He paid me $10,000. I sent him the picture of the house because that was all there was. So these are interesting contracts which are happening on a day-to-day basis. There is also another jurisdiction. இப்ப இதெல்லாம் எங்க, who is going to adjudge? Where is the product made? Where is the product advertised? Where is the product sold? All right. So all these, you are going into a realm of completely different manner in which goods are actually being advertised and sold. And the norms that would apply to these would be vastly different from the norms that have been applied to interpretation of contracts that existed earlier. So this is the challenge that is going to come up in recent times. That is why in the definition of consumer, all these have today been included. Today you will be called on to interpret what an online contract is, what an offline transaction is, what is an electronic teleshopping, what is multi-direct selling, what is multi-level marketing. These are all words that are going to come up before you for interpretation in the near future, because this act is only in 2019. So the purpose of this session is to show the way in which all this should be interpreted. Now, the second is, of course, a simpler change. The district forum is now termed as a district commission. And then the original pecuniary jurisdiction of the district commission shall not be more than 1 crore. State commission is from 1 crore to 10 crores, and national commission about 10 crores. In the words Allah, some of these words, they can cause problems. They have caused problems earlier. For example, if the pecuniary jurisdiction of the district commission shall not be more than 1 crore. So what does happen to 1 crore? Is 1 crore more than 1 crore, less than 1 crore? There was one problem with regard to interpretation that has now been addressed now. But previously it said were used words which caused a confusion with regard to pecuniary jurisdiction. Now, the complainant, most important provision is complainant can institute the complaint within the territorial jurisdiction of the commission where the complainant resides or personally works for gain, besides the earlier provisions. That is going to be a huge help to the consumer. The limitation period for filing an appeal to the state commission is now 45 days from the date of order. Earlier, the same was 30 days from the date of order, retaining the powers to condone the delay. The state commission shall have minimum 1 president and 4 members. Before filing an appeal before the state commission, the opposite party needs to deposit 50% of the amount ordered by the district commission. Earlier, the maximum limit of is 25,000, which has been deleted in the new act. The e-filing of complaint is a main attraction under the new act. The commission can file his complaint online and can attend the hearing or examining witnesses via video conference. Now, there is a very important provision which has been introduced, which is the product liability. Product liability means the responsibility of the product manufacturer or product seller to compensate for any harm caused to a consumer by such defective product. Earlier, no one was held responsible for the harm caused by the product, but now the service provider or the manufacturer or the seller, which includes e-commerce platforms, will be responsible for any harm caused by the product. So these are even earlier. There have been a lot of interpretation of these provisions, and in fact, there have been conflicting judgments of the even the Supreme Court. For example, when I was writing my book on the Consumer Protection Act, one of the issues that I had to deal with is, can a company be a consumer? Can a company be a person? On the same day, there are 2 judgments of the Supreme Court, one saying company can be a consumer, and another delivered on the same day by the Supreme Court saying company cannot be a consumer. So these are problems in interpretation which have traveled up till the Supreme Court and have been become the subject matter of issues before the Supreme Court. And one other problem which you will face on going once again from interpretation of the statutes and the provisions is, can an application be filed to set aside an ex parte order? The amount of confusion that has gone into deciding this issue is truly remarkable. Because முதல்ல என்ன பண்ணாங்க, there were two judgments which contradicted each other. First one, there is Grindlays Bank versus Central Government Industrial Tribunal. இது வந்து நான்லாம் பிராக்டிஸ் பண்ண ஆரம்பிச்ச புதுசுல this Grindlays Bank case was cited by us, AR 1981 Supreme Court 606. In this case, the question arose whether an industrial tribunal will have the power to set aside an ex parte order. The Supreme Court said that when a tribunal is vested with powers of adjudication, all powers that are incidental to it will also be vested with that tribunal. So the tribunal will have powers to set aside ex parte order. This Supreme Court said in AR 1981 Supreme Court 606. Subsequently, there were two judgments of the and this line of thought was also confirmed in VK Money versus DCRF of the Madras High Court in CRP number 2215 of 1992, where they said they followed Grindlays Bank and then said that district forums can and state commissions and authorities functioning under the provisions of the Act could set aside this ex parte orders. But even render judgments post problems. One is New India Assurance versus R. Srinivasan, and the other is Jyotsna Arvind Kumar. New India Assurance versus R. Srinivasan 1996. Why is because these two said two opposite, diametrically opposite. One said it can be done, the other said it cannot be done. Therefore, the matter went up to the Supreme Court. The Supreme Court said 2011 in the Virendra judgment, Supreme Court said that consumer courts are creatures of the statute. So you cannot step outside the provisions of the statute. There is a power of review vested with the National Commission, and there is a power to recall orders vested with the National Commission. Therefore, it is only the National Commission which can set aside ex parte orders or review its orders. This is the judgment given by the Supreme Court. But in 2019, there is an amendment to the Act. The National Commission has the power of review. They did not want the Supreme Court from being flooded with cases from the National Commission. So, let the National Commission itself deal with all these issues. Instead of the matter landing up before the Supreme Court, they gave the power only to the National Commission. That power was not given to the district forum under the Act or the state commissions. Supreme Court, Virendra judgment, they say two things, that there is a power of review, there is a power to set aside ex parte order. Therefore, you can. Now, 2019 amendment, the district forum, state commission, National Commission, all of them have power of review. But only the National Commission has a power to set aside the ex parte order. So what is the resulting situation today? You have to read the judgment of the Supreme Court in Hitendra case along with the 2019 amendment. So since there is no power to set aside the ex parte order, once again this will lead to two different classes of cases before the district court. Suppose you have a case, and suppose you decide that even though the parties are not before you, you will decide the case on merits and pass an order. You pass an order. The aggrieved party files a review. You can entertain the review. You can go into all aspects of the matter, decide whether your order is right or wrong. Let us assume that the complainant is not present before the court, and you just proceed to dismiss the complaint. The situation today remains that notwithstanding the judgment of the Supreme Court in Grindlays Bank, AR 1981 Supreme Court 606, which unfortunately has not been brought to the attention of the Supreme Court in all these other cases. In spite of that judgment, because of the judgment of the 2011 judgment of the Supreme Court, you will be powerless to restore the complaint, and the matter can only go on appeal before the state commission. So this is once again problems of interpretation that are arising. Supreme Court itself says two things. Supreme Court says when there is a tribunal, it must be deemed to be vested with all powers incidental, even though there are no specific words in the Act. That is the ratio of the judgment in Bentley's back. That even though there is no specific provision, the tribunals created under the Act are deemed to be vested with all incidental powers. Therefore, you can set aside an ex parte. And that judgment, as I said, has not been brought to the attention of the Supreme Court, and the Supreme Court has gone on a literal construction basis. So the literal construction says that since there is no specific power to set aside an ex parte decree, the powers must be construed to mean that there is no power to set aside or recall an order set ex parte. So today, actually, it falls within two classes. If you go ahead and decide the matter on merits, then you can entertain a review, set aside even if you have decided it ex parte. But on the other hand, that if it is setting aside ex parte order, then the problem will be that you will not have the power to. So this is once again a problem caused by interpretation of statutes. But the Supreme Court is final, and we will have to go by what the Supreme Court says as far as interpretation of the provisions of the Act is concerned, unless there is going to be another provision which defines it differently. Now, let us look at, so this is the broad basis on which the Act has been defined. Now, let us look at some of the interesting cases where the various provisions of the Act have actually been applied. As I said earlier, please refer to the provisions when a judgment is cited before you. Please refer to how the Act has been interpreted, how the Act has now been defined. உங்களுக்கு ஒரு சின்ன உதாரணம் கொடுக்கிறேன். இந்த ஆக்ட் வந்த புதுசுல goods that are purchased for a commercial purpose are excluded from the purview. Somebody goes.
So your voice is breaking. Not able to get the voice.
Let us say an equipment or a machinery for his factory. That would be other way. If there is going to be a purchase for self-employment or for eking out a livelihood, then it would be included. But in the distinction, the definition of services like ilda. So from 1986 till 2002, when this provision was brought in to exclude services which were availed of for a commercial purpose, இது வர வரைக்கும் 1986 to 2002 வரைக்கும் commercial purpose-க்கு if services are availed for a commercial purpose under the provision of the Consumer Protection Act, you could still file a complaint. நாங்க எவ்வளவோ ஃபைல் பண்ணிருக்கோம். சோ இப்போ இந்த क्वेश्चन உங்களுக்கு முன்னாடி யாராவது ஒரு 1999 ஜட்ஜ்மென்ட் இல்ல 2002 ஜட்ஜ்மென்ட் எடுத்து சைட் பண்ணாங்கன்னா it will have no validity. So what is important in interpretation of statute and to understand the provisions of the statute, or even where a case law is cited before you, you will have to understand the provisions of the Act as it stood then, right? And interpret the words in the manner in which they existed earlier. முன்னாடி இருக்கிற சர்வீசஸ்க்கு இது பொருந்தாது. சோ இப்ப நிறைய கேசஸ் எப்படி ஃபைல் பண்ணாங்கன்னா, I purchased machinery for a commercial purpose, but there was a warranty to the purchase of the machinery. Even the warranty terms pragaram, if there is a defect, and if I complain saying there is a defect, நான் ஒரு கம்ப்யூட்டர் வாங்குறேன், ஒரு 10 கம்ப்யூட்டர் என் ஆஃபீஸ்க்கு வாங்குறேன், 10 கம்ப்யூட்டரும் கவர்ட் பை வாரண்டி. நான் வந்து கம்ப்யூட்டர் சரியில்லைன்னு நிறைய கம்ப்ளைண்ட்ஸ் ஃபைல் பண்ணியிருக்கேன். But none of these complaints have been attended to. Therefore, I am now covered by the provisions. Abdin, we used to file complaints. All these were addressed and were taken up for consideration, and remedy was also granted by the consumer courts. But அதையே 2003ல இதே கம்ப்ளைண்ட் 2003ல பண்ணிருந்தாங்க. நான் ஏன்னா அதுக்குள்ள பார்லிமெண்ட் woke up to this defect in drafting. Right? என்ன பண்ணுவாங்கன்னா, most developed countries the law எப்படி டெவலப் ஆகுதுன்னு ட்ராக் பண்றதுக்கு they will have authorities. So frequently, to avoid this confusion, they will introduce amendments to various acts. Right? For example, the Arbitration Act in Singapore in 2001. But between 2001 and 2019, the act has gone through 6 amendments. But நம்ம இந்தியால வந்து 2001ல இருந்து இது வரைக்கும் பாத்தீங்கன்னா ஒண்ணுதான் மேஜர் அமெண்ட்மெண்ட். மத்ததெல்லாம் வந்து 2019ல வந்ததெல்லாம் மைனர் அமெண்ட்மெண்ட்ஸ். So in interpretation it causes huge confusion. இதை அவாய்ட் பண்றதுக்கு பார்லிமெண்டே ரெக்டிஃபை பண்ணிடுவாங்க. Right? And the provisions are also, for example, in the problem about ex parte order, இது என்ன ஒரு டிஃபரன்ஸ் உங்களுக்கு புரிஞ்சுக்கணும். The power of review is on 2 aspects. The first power of review is a power of review in respect of procedural issues. The second power of review is a power of review in respect of merits of a case. This distinction, unfortunately, has not been argued before the Supreme Court. A forum will always have the power of review in respect of procedural matters that come up for determination. But in respect of merit matters, unless that power is vested with the forum through a legislative license, it cannot be exercised. Right? So review on merits, unless there is a power in the act, it cannot be done. But setting aside ex parte order law is just a review on procedure. That must be, I don't know, at least as far as I am concerned, Brindley's Bank case is the correct judgment on that. This distinction has not been appreciated by the Supreme Court while passing an order that ex parte order cannot be set aside. Right? So a review on procedural matters or all procedural issues can still, that is why if you look at the powers of the commission, of the district commission, I think I'll just you take the Consumer Protection Act, there is a power given to the central government to provide for something which is not there. So in the reference to, if all the district forums can write to the central government, the central government itself can bring out a change and say that power of it need not be brought in through a legislative amendment, is at least what I think it should be. And these changes, see, if you take section 38(9), section 38(9 of the Consumer Protection Act, it sets out the powers. அதுக்கப்புறம் இருக்கிறதெல்லாம் procedure on admission of companies. Section 38, there are very elaborate provisions given with regard to how the State Commission says that these same provisions will apply to the State Commission with whatever changes are appropriate. National Commission says the same will apply with regard to taking on some changes where necessary. But the 38(9) like says, for the purpose of this section, district commission shall have the same powers as are vested in the civil code under the Code of Civil Procedure while trying a suit in respect of the following, namely, அப்படின்னு சொல்லிட்டு, if you look at F, any other matter which may be prescribed by the central government. So if all the state commissions were to write to the central government and say there is a bit of a lacuna in the act with regard to setting aside ex parte orders, Therefore, kindly specify that under 38(9)(f), we will also have the powers. Then it can just be done by a central government notification, because this is a matter of procedure. And it is also strange to say that a district commission, the state commission, and the national commission will have the power of review on merits, but will not have the power to set aside an ex parte order, which is just a matter of procedure. It is anachronous that there could be a provision to review on merit, but no power to set aside. So the very simple way to deal with this situation is just for the state commissions to write, at least the major state commissions in the country can write to the central government and say, resolve this because this is a procedural matter, and annex the judgment of the Supreme Court in Gringley's Bank case and say that please clarify that there is a procedure to set aside ex parte orders. So these are all powers. Very rarely is the central government given the power to has exercised this power, but that will be exercised by the central government only if the state commissions write to the central government and ask for this procedure to be made clear and all these confusions to be resolved. So, actually, today, even in respect of the confusion with regard to limitation, what happens during the corona period? The corona period, how is it to be dealt with? The Supreme Court has passed an order. What is the period? How do you interpret the period? And because the salutary law interpretation is, if a particular the fundamental salutary principle in statute interpretation is, if the law says that a thing has to be done in a particular way, it should only be done in that way. Right? So a law says that within so many days you have to file your defense statement to a complaint that has been filed. The law also prescribes a period for appeal, for continuation of delay. What happens if an application is filed beyond that period? Right? So the interpretation by the Supreme Court has been that from following J.J. Merchant case till the new case, that this is a time-bound process and you have to honor the time prescribed. But COVID stuck. So there is a problem. So Supreme Court has now in 2021, in the general suo motu order extending the time, said how various fora must deal with this period and how it should be. Following this, the National Commission has come out with clear guidelines. I'm sure that all the district members will have a copy of that order. Otherwise, it must be sent to all the district commissions, where the National Commission has explained exactly how period of limitation must phenomena which is stuck, a natural pandemic which is stuck, and you have a problem relating to that. Can you hear me? No?
Actually, the last 5 minutes, we were not able to hear you.
Oh, right. Some connectivity. So, what I was explaining is that please stop me if there is any problem, if any of you can't hear. So, what I was explaining is that there is a provision of the Act which says when the defense statement has to be filed to a complaint, what is the period for condoning the delay in filing the complaint and how it must be dealt with, right? Now there is a provision which has been introduced. Now there is a problem that we have on account of the pandemic. So the question is, how do I deal with this situation? In a suo motu order relating to limitation, the Supreme Court has clarified how the period of limitation has to be calculated under various statutes. Now, the application of the order of the Supreme Court, the National Commission has taken great responsibility in setting out very clearly how that must be applied to the cases that come before the various fora under the Act. So what I was saying is, I hope that this has been distributed to all of you and you have the benefit of this circular of the National Commission, which explains the manner in which this period of limitation for filing the defense statement and appeals and various other aspects of the Act are considered. So this is what I was saying in the last 5 minutes. So we come back to the interpretation of the terms, right? So one of the interesting questions that came before the Supreme Court is whether a prospective investor in future goods could be treated as a consumer. That was a case relating to shares. So the Supreme Court said, as per the definition, consumer is one who purchases goods for private use or consumption. The meaning of the word consumer is broadly stated in the definition as to include anyone who consumes goods or services at the end of the chain of production. The comprehensive definition aims at covering every man who pays money as the price or cost of goods and services. The consumer deserves to get what he pays for in real quantity and true quality. In every society, consumer remains the center of gravity of all business and industrial activity. He needs protection from the manufacturer, producer, supplier, wholesaler, and retailer. Therefore, the Supreme Court opined that a prospective investor in future goods was not a consumer. That is Morgan Stanley Mutual Fund versus Karthik Das. The Supreme Court has also had occasion to deal with, as I told you, it has to come up with some simple tests to determine who will be a consumer. Supreme Court says goods are not for immediate final consumption, but there is only a transfer of goods, that is resale. Okay? A person who is only an intermediary for purchasing certain goods and passing those goods on to another person is a person who is acting for resale. Such person is not a consumer. Then there should be a direct nexus between purchase of goods and the profit or loss from their further disposal. Such a direct nexus is absent when the goods or services are converted for producing other goods or services. The goods that you purchase are the input for manufacturing other goods and other goods. Then once again you are only a intermediate. There is nexus of form of kind between the goods purchased and the goods sold. Such a direct nexus of form and kind ceases when the goods undergo transformation or conversion. Applying these principles in Spia plastic industry versus Karthik heavy equipment tools, it was held by Kerala State Commission that the purchase of a molding machine, including a semi-automatic HP motor by the complainant firm, engaged in the manufacture and sale of plastic articles, was held to be for a commercial purpose. Similarly, in the Eagle Ultramarine Industries case, where the complainant firm was engaged in the business of manufacturing of what is called, you would have all seen it in those days, ultramarine blue. And it got the air pollution control system installed from the opposite party for consideration, which did not satisfy the standard required by the pollution control. It has been held that the petitioner company having procured the equipment for commercial purpose cannot be regarded. Now, in these cases again, there is a distinction in interpretation. Sometimes the National Commission has embarked on this question that whether the goods that have been purchased have any final nexus with the industrial activity. If there has been a direct nexus between the purchase of the machine and the industrial activity, that has also been one of the standards which the consumer courts have held. Many of the cases before the commission and before the district forum came in respect of Machineries which have been purchased. For example, a widow purchases a sewing machine to eke out a livelihood. Now, can you consider that to be a commercial purpose? Yes, she is going to make money out of it, but it involves the labor of only that poor woman. Only she is going to do work on it. He is not going to have a large scale industrial unit, employ her labor or the machine that she has purchased. So a widow goes and purchases a sewing machine to eke out a livelihood, or let us say even any woman under a women welfare development scheme is given a loan and she goes and purchases a sewing machine. Would that be a purchase for a commercial? Courts have said no, that they are not a purchase for a commercial purpose. And the classic case is, of course, the case is the Dynavox Electronic Limited, when the photostat machine was purchased for personal use in order to make a livelihood. It was held that the transaction, the purchase of the photostat machine, would not constitute commercial. This was held in 1999, 1 CPJ 594, Dynavox UP, Dynavox Electronic Limited by the UP State. And SP Goel versus Collector of Stamps is an authority. 1996, 1 Supreme Court 68 is the case that I referred to earlier, where a person goes and presents a document for registration and he pays the stamp duty on it, but he does not become a consumer, nor do the officers appointed to implement the provisions of the Indian Stamp Act and the Registration Act render any service within the meaning of the consumer. Now, there the Supreme Court held that the person, because these were sovereign functions. And recently the Supreme Court had occasion, New India Assurance Company Limited, 2020 SEC, page 71, is the one that I told you about the limitation period, where the Supreme Court considered section 13(2). So, PUDA, Puda versus Vidyachalan, is a judgment on this distinction between sovereign functions and non-sovereign functions. But there is one paragraph that is causing a little discomfort to me in that judgment, which is para 16. So the Supreme Court by and large says that even if it is a statutory function, then the doors of the Consumer Protection Consumer Act cannot be shut. So it says that in respect of statutory functions, what has to be considered is when the purchase of goods or services. That is the what you have to consider. Sovereign functions are accepted, but because it is a statutory function, it doesn't mean consumer courts are not consumer courts have no jurisdiction, except where alternate remedy is provided. That again, that observation of the Supreme Court causes me some discomfort, because under the section 3 of the Consumer Protection Act, the remedies under the Consumer Protection Act are not in substitution, but in addition to the remedies provided under other acts. So now there is a problem because of that para 60, which I thankfully till now nobody has used it in the Consumer Court. But when it comes up before the Consumer Court, what is the interpretation to be given? There is the Act itself says that it is in addition to and not in derogation of the provisions of other acts. Take a simple case under the Electricity Act, right? Under the Electricity Act, a consumer comes before the commission and files a complaint in respect of a particular matter, which is well within the jurisdiction of the Consumer Court. Now, there is a hierarchy of authorities who have been created under the Electricity Act to give relief. There is at the first level, the Consumer Grievance Redressal Forum. Above that, there is a state ombudsman. And in respect of generator licensee disputes, there is a state commission. Above the state commission, there is APTEL. Above APTEL, there is the Supreme Court. Now, this is the hierarchy of authorities under the Electricity Act. There are several decisions of the National Commission which says that even in respect of electricity matters, you can file a complaint. But now in Puda versus Vidyachalan in 2019, is decided on 16th September 2019. The Supreme Court says what the Commission has to also take into account is whether remedies have been provided under specific enactments. So if remedies have been provided under specific enactments, does that mean that the consumer courts lose jurisdiction even though the provisions of the Act very clearly state that the remedies afforded under the Act are in addition to and not in derogation of the provisions of another. Now, this is going to be another sticky. But basically, consumer courts have to go according to what the Act says, and the judgment of the Supreme Court in Tuda Vidyacharit must be taken as a judgment which has been rendered in the facts and circumstances of that case. So there is, that is why I said, in the interpretation of statutes, you have to give primary importance to the words of a statute. And since the Act very clearly says that the powers are in addition to, not in derogation of, the consumer courts will have jurisdiction. Insurance Act also. Now there is an ombudsman. You can go before the ombudsman. Against an orders of an ombudsman, you can file a writ petition. But can you say on account of that, one cannot file a complaint before the consumer courts? You can't say that. Again, let us take some statutory housing authorities. If an appeal, if a provision for a complaint is provided, if you can file a complaint somewhere, does that mean that the consumer courts have no jurisdiction? So this is why the Parliament in its wisdom has said that in addition to and not in derogation of. So merely because there are provisions in other acts, it will not exclude the provisions of this act. In sovereign functions, yes. For example, issuance of a patta. Issuance of a patta is regulated by the provisions of the Patta Passbook Act. And under the provisions of that act, there is an authority, there is an appellate authority, there is a revisional authority. From the revisional authority, you go to the High Court. In respect of sovereign functions, therefore, the judgments of the Supreme Court in Huda versus Vidyacharit must be interpreted to mean where, in respect of a sovereign function, there is also a hierarchy of appellate authorities created, redressal authorities created. Then, in such cases, cases can go before them, but that judgment will not apply to cases where mere statutory remedies have been afforded in other acts. So, a large number of cases.
Take a 10-minute break, sir?
Yeah, take a 10 minutes.
Okay. So we'll just break for 10 minutes. I think it's not fair to actually ask him to speak continuously. So I think we should give him this 10-minute break. So we'll break for 10 minutes and we'll rejoin. Yeah, yeah. We'll rejoin by 4:15. Yes. Thank you.
Yeah.
Thank you. Mr. Raja just called and he has requested for 10 minutes time before he joins. Thank you. Yes, sir.
Now, can you hear me?
Yes. Okay. Shall we start?
Yeah.
Yes. There is a request, sir, before we go into this, there is a request in the chat box asking you to share the rulings cited by you.
Okay, I will send it separately because I can just give you the rulings, but it will be difficult for me to. Through CAG, we will send it to everybody.
Yes, sir. We can share it with the State Commission and they could
Yeah,
probably.
the State Commission will then distribute it.
Yes, sir. Thank you.
So, in the next 1 hour, I will just, because we are concerned with the interpretation of statutes, I will take you through the vexing questions that have been before the consumer courts for this. Just give me a minute. Yes. So we will look at some of the questions that have come up before the consumer court in respect of the interpretation of the provisions and how the consumer court have dealt with it. Then the question has been, who is a consumer, right? So the consumer under the Act is not necessarily an individual. The word used under the Consumer Protection Act is person. Therefore, a company or a partnership by virtue of the definition contained in the General Clauses Act, as also under the Act, a body of any person forming an association for purpose of a common purpose and acting jointly are persons within the extended definition and are consumers within the ambit and scope of the Consumer Protection Act. So, any authority, any body who falls under this will be a consumer, except the following: A, the goods are obtained for resale, or B, goods are obtained for any commercial purpose, subject to the explanation that commercial purpose does not include use by a consumer goods brought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. Right? Then you have the oft-repeated questions of commercial purpose. And the Supreme Court has said in Leelavati Kirtilal Mehta Medical Trust versus Unique Shanti Developers and others, which is 2019 SEC online, Supreme Court page 1466. The question of whether a transaction is for a commercial purpose would depend upon the facts and circumstances of each case. However, ordinarily, commercial purpose is understood to include manufacturing, industrial activity, or business-to-business transaction between commercial entities. The purchase of goods or services should have a close and direct nexus with the profit-generating activity. The identity of the person making the purchase or the value of the transaction is not conclusive. You don't go by the identity of the person or the value involved. If it is found that the dominant purpose behind purchasing the good or service was for the personal use and consumption of the purchaser and or the beneficiary, or is otherwise not linked to any commercial activity, the question of whether such a purpose was for the purpose of generating livelihood by means of self-employment need not be looked at. And one of the Other very unique features about the Consumer Protection Act, where it makes a departure from the principles of the Contract Act, is it includes within its purview even the beneficiary of a service. Normally, if you go to a civil court and try to sue on the basis of a contract, the first question which the court will, if a defense is taken that there is no privity of contract, that would be the first question which the court will take up for consideration. But because of the peculiar definition of the definition of consumer under the Consumer Protection Act, even a beneficiary of a service is included within the definition of a service. So it is true that normally in ordinary conventional field of law of contract, the doctrine of privity was paramount. However, the definition of the term consumer in section 2(1)(d) of the Act removes the constraints of that doctrine. It designedly extends its ambit of protection of lawful beneficiaries of services of the person who hired out the services of the beneficiaries to avail them with the approval of the original hirer. The latter comes well within the beneficial provision of the statute. This is what the was held by the court in B.S. Sidhu Doctor versus Central Government Post and Telegraph Department. Then comes the perplexing question as to whether if a owner of a plot enters into a contract for joint development, would that come within the purview of the consumer? This is a large number of cases in which this question came up for consideration. That is, I am the owner of an extent of land. I enter into a joint development agreement with a builder, and the builder says that I will not give you consideration in money, but what I will do is I will develop your land, and if I'm going to put up 10 flats, I will give you 4 apartments in the constructed area. Now that the question arose as to whether that would fall and if there is any mistake or whether there is any problem. Originally, the National Commission held that in respect of joint development, the owner cannot be termed as a consumer. But that judgment came up for reconsideration, and ultimately the Supreme Court held in Fakirchand Gulati versus Uppal Agency Private Limited, which is reported in 2008 NACC page 345, that there are 2 types of transactions where the builder and the owner form a partnership, separate partnership firm, and the partnership decides to develop that property. And it is decided that the profits will be shared by the owner and the developer. That will be different from a case where the owner merely offers his land for development, and the development is put up with that land, and the owner takes X number of apartments as consideration for having offered this land for development. So the Supreme Court said that these are 2 different types of cases, and in a case where there is no partnership, there is no joint venture, so to say, in the commercial transaction, and the owner of the land is merely offering his property for development, the owner will continue to be a consumer. The Supreme Court held there is no dispute or doubt that a complaint under the Consumer Protection Act will be maintainable in the following 2 circumstances: where the holder of land has instructed the construction of a house to a contractor, has a complaint of deficiency in service with reference to the construction, and B, where the purchaser or the intending purchaser of an apartment, flat, house has a complaint against the builder developer with reference to the construction or delivery of amenities. However, in this case, the Supreme Court has concerned the 3rd hybrid category, which is popularly known as joint venture agreements or development agreements or collaboration landlord and the builder. In such transactions, the landlord provides the land, the builder puts up the building, thereafter the landholder and the builder share the constructed area. Supreme Court held that such cases will also fall within the provisions of the Consumer Protection Act. Then the other types of cases is where there is a purchase in an auction from a development authority. This again is a large number of cases, especially in the Chandigarh Housing Development Authority, Lucknow Development Authority, which landed up in the Supreme Court. And the Supreme Court held that the complainant will fall within the definition of a consumer. Where the complainant had purchased the site in an auction from the Bangalore Development Authority, and this being a case of outright sale of a movable property at an auction, it has been held that the complainant will not be a hirer of service Bangalore Development Authority, and he will not be a consumer within the meaning of Section 2 of the Consumer Protection Act in cases where there is a mere transfer of property, as distinguished from any case where services are to be rendered by the authority. So you must once again make a distinction between the cases where it is a simple purchase of immovable property as against a development of a property and sale of that property, which are the subject matter of Lucknow Development Authority versus FJ. So once again, you will be called on to make the distinction between these two classes of cases. The third is are cases, once again, in respect of matters where services which were availed for a commercial purposes were not excluded under the Consumer Protection Act till 2002. The classic case is when a bank guarantee was got issued by the firm from the Bank of India favoring the company, which was revoked. And in the complaint under the Consumer Protection Act, objection was raised by the bank that there was no privity of contract between the bank and the company, and therefore the latter cannot make any complaint against the bank under the Act. It was held that the company is clearly the beneficiary of the contract of service that is entered into between the firm and the company, and thus the company falls under the definition of a consumer. This is Bank of India versus HCL Limited, 19.
So we have lost you.
Yeah.
Yeah.
Can you hear me?
Yes, sir.
Yes, sir.
Can you hear me?
Yes, sir.
Okay. So this is Bank of India versus HCL Limited, 1993, 2 CPG 257. But why I am citing this case is because these types of cases, when they come before you now, it will be plain that they will not come within the provisions of the Consumer Protection Act on account of amendments to the Act that has happened subsequently. So these judgments will not be good law. These judgments will not be good law anymore. The third is, there's an interesting argument which was raised as to whether it is a consumer dispute. The complainant had made deposits with the bank, fixed deposit, and the opposite party was to service that fixed deposit and to give interest at periodical intervals. Since this was not done, there was a question as to whether this will come within the purview of the Consumer Protection Act. And the National Commission held that in cases of deposits for a fixed period, it was argued on behalf of the opposite party that the complainants cannot be treated as company, as a company is not rendering any services towards them by merely accepting the deposit for fixed deposit, which argument was turned down by the National Commission, which held that the company is rendering financial services and receives deposits from consumers and pays interest thereof. This case is interesting because an argument was taken. If a financial institution takes a deposit from me and agrees to pay interest on the same, it will neither be purchase of goods nor rendering of services. Because what service am I rendering? So the National Commission shot down that argument and said that if you take money from a consumer and promise to pay him interest, that will come within the definition of financial services, and you cannot escape liability by pleading that it is neither goods nor service. So this was a case where the National Commission held that these cases would come within the definition of financial service. Then one other interesting issue on financial services arose before the National Commission in respect of certain statutory duties that was performed by the Reserve Bank of India when it regulates foreign exchange. So the question before the court was whether the Reserve Bank of India can be hauled up before the consumer court in respect of an alleged deficiency in service relating to disbursement of foreign exchange by application of certain rules. The National Commission held that the Reserve Bank of India was merely exercising its statutory function as a statutory authority charged with the task of enforcing the provisions relating to foreign exchange control contained in the Foreign Exchange Regulation Act. It was held that while acting in the said capacity, the Reserve Bank of India cannot be said to be rendering any banking service to the complainant, nor was there an element of hiring of service. So this was a case where, once again, what was invoked was the foreign function, sovereign function. So regulation of foreign exchange only the government can do. The manner in which the government will regulate foreign exchange is set out in the provisions of the Reserve Bank of India Act and is done by them. So it was held that this will be outside the jurisdiction of the Consumer Protection Act because once again it is a sovereign function. The most important set of cases before the Consumer Court arose out of the interpretation of the contract of personal service and contract for personal service. The Supreme Court held that prima facie test for determination. This has been an issue which has been before the Supreme Court even before the Consumer Protection Act came into existence. So, in terms of the application of industrial laws, in Executive Committee of Vice Degree College versus Lakshmi Narayan AR 1970, Supreme Court 888, the Supreme Court had to go into the question as to what creates a master-servant relationship. Prima facie determination for the determination of a relationship between master and servant is the existence of the right of the master to supervise and control the work done by the servant. Not only in the matter of directing that work the servant is to do, but also the manner in which he shall do the work. The correct method of approach would be to consider it must be noted the work done there was due control and supervision by the employee. So this was
So your voice
stipulated by the Supreme Court as the
voice
test. It must be noted that all these doctrines of contract of service as personal, non-assignable, unenforceable, and so grew in an age when the contract of service was still personally a personal relation between the owner of a small workshop or trade or business and his servant. So, primarily, what is a contract for personal service and a contract for personal service? Contract for personal service is that which creates a master and servant relationship. The master must be able to regulate the manner in which the employee executes his functions. But in the contract of personal service, even though there is an element of personal service, a master-servant relationship does not exist. This was the basis of the National Commission and ultimately the Supreme Court holding in Indian Medical Association versus VP Shanta and others, which is reported in AR 1996 Supreme Court 550, that the services done by a doctor to a patient will come within the purview of the Consumer Protection Act because no master-servant relationship exists. And therefore, these are services which will be within the purview of the Consumer Protection. A doctor is not the servant of the patient who engages him. He is not going to act on the dictates of the patient. The court also went on to consider the question because several arguments were raised by doctors with regard to the jurisdiction of consumer courts to hear matters relating to deficiency in medical service. The Supreme Court, by a very elaborate judgment, went into all these aspects and held that these will be within the purview, but there were certain safeguards that were provided. Primarily, the person who alleges the onus of proving a deficiency in service will be on the person who alleges that deficiency in service. So if I go before a consumer court, except in cases of re ipsa loquitur, as they are called, where a thing speaks for itself. What are these types of cases where the doctor is supposed to operate on the right side and he operates on the left side? The case of negligence there is writ large in the procedure itself, and no further elaboration is required. Likewise, if a doctor leaves a forceps inside the stomach of a patient and stitches up the stomach, then that would amount to negligence. These don't require a great deal of elaboration because re ipsa loquitur is a Latin term, and the translation of that is this speaks for itself, right? It is evident, it is apparent, it is patent. So, in all such cases, obviously the consumer courts will have jurisdiction. But there are a more complicated set of cases where negligence has to be proved, and a deficiency in service will arise out of that negligence. What is negligence? What is professional negligence? Very simply put, it is the failure to do something which ought to have been done, or doing something which ought not to have been done. Therefore, the determination before the court in all such cases is whether something which ought to have been done was not done, or something which ought not to have been done was done. How does a court determine what is to be done, what is not to be done? Now, that question can only be answered on the facts and circumstances of each case, and it would be very difficult to lay down some uniform principles applicable to this. But generally, the court has to be guided by medical literature. It's very difficult to get doctors to give evidence against doctors, so that is not going to happen. You have to look at accepted textbooks on medical negligence. In all this, the work of a court is not very easy. It is going to be difficult. But there are certain guiding standards. There are ethical regulations which are brought out by the Medical Association. And there was also some cases where the National Commission sent the facts of a case to reputed institutions like the All India Institute of Medical Sciences and asked them to form a team of doctors to look at the case records and to give some opinion as to whether this is right or wrong. But unfortunately, those have also not been met with favor by the National Commission. So ultimately, it has been left And even though the proceedings before the consumer courts are supposed to be summary proceedings, and in a matter relating to medical negligence, except the categories where the negligence is very obvious, evidence has to be there. There has to be cross-examination of the complaint. There has to be cross-examination of the opposite party. And ultimately, since it's a civil case, because in the criminal, there can be two types of cases. You can also sue a doctor for negligence before the criminal court. But if you sue a doctor for negligence before the criminal court, there you will have to prove the case before beyond all reasonable doubt. Whereas if you sue a doctor in the civil court, it has to be probabilities of the case. Right? So this is a very difficult task for the district commission. But what is the advantage is over these very many years, there is a body of case law that has developed. In America and in all the other Western countries, the task is made much more easier because in respect of treatment of possibly every recognized medical symptom, there are guidelines of treatment. That's why a doctor's job in America is very easy because there is a website called guidelines.com, the medical profession. So if you go into it, in respect of every particular problem, medical problem, what must be done, A, B, C, D steps. And many times it just becomes a checklist for the doctor to check, and it becomes a procedural matter. And cases of medical negligence there are an attempt to show that that procedure, which has been accepted by the medical community and like-minded persons, has not been followed. So there the determination is much simpler. But in India, the various the Orthopedic Association has not come up with guidelines. The ophthalmologists have not come up with the guidelines. So the task of an Indian court is much more complicated than what it is abroad. Abroad, it's much more easier. So today you have to not only determine what is negligence, but before you determine what is negligence, you also have to go into the issue as to whether a proper procedure, standard procedure to be adopted in that case has been followed or has not been followed. And it is also difficult. For example, in America, it is standardized. So a person can't say that this patient was in the village and these facilities are not available in the village and therefore we did not provide them. That cannot be a stand taken in America because basically it is all with regard to right to life. And in whichever part of the country you are entitled to the same standard of care and attention. But in India, we can't say that. But if a person is to be treated in the village, obviously, what is when the doctor takes on the treatment of the patient, he can only do whatever is possible under the circumstances. So he cannot be expected to have facilities, medical facilities that are available in a hospital in Chennai or Mumbai. So these are drawbacks in the deciding cases relating to medical negligence. But unfortunately, what is also the other fact is we can't throw out these cases. We can't throw out these cases. Because the medical body itself can ask the Medical Council of India to give you statistics of how many cases of doctors they have debarred on account of negligence. Hardly any. Compared to the Advocates Association, which debars on a monthly basis at least a few advocates. So the help from the professional body is also not there. So the consumer is actually left without a remedy because if we go to a civil court and file a case and the matter comes up for hearing, it is a very, very tortuous process. And let us assume that there is a doctor who is guilty of negligence. By the time the case takes a good 10 to 15 years to be decided, unfortunately, if that doctor is left unchecked, then there is a potential that he may cause At the same time, the reputation of a good doctor also has to be protected. So this becomes a little more complex, but this is a cross which the consumer courts have to bear. Matters cannot be thrown out of court only because these require elaborate evidence. Because many of the cases that do require elaborate evidence have been considered by the National Commission and by the Supreme Court. And today, as I said, the advantage is there is a good body of case law which will tell you what cases can a doctor can be held guilty of negligence, and in what cases he cannot be held guilty of negligence. There's an answering question to that. The answering question to that: what happens to government hospitals? They also render medical services. Are these services within the purview? The person getting a treatment there, a consumer, within the definition of the consumer. In VP Shanta's case, the Supreme Court held that in all medical institutions which profess to give, there is not only government hospitals, there are also various charitable institutions which offer treatment at subsidized cost or free of cost. So let us take the different baskets. If it is completely free of cost, there is no money that is levied at all, except for medicines, let's say. Those are outside the purview of the Consumer Protection Act, whether they are rendered by private hospitals or by government hospitals. That is the first category. The second category is where there is subsidized cost, either in the government hospital or in private hospitals. Even if there is subsidized cost, it is assumed that the person who receives the subsidy is a beneficiary. Because I told you earlier, right, that the definition of a consumer includes a beneficiary of a beneficiary. So in such cases, the beneficiary, the consumer, the person who receives subsidized treatments becomes a beneficiary of the services, and therefore he will be within the purview of the consumer. The third class of category is no money is received from a patient, but it is not as if that hospital itself is completely free of charges. So the patient does not pay any money. But there are other categories of cases who are admitted in the hospital from whom consideration is. In such cases also, the court said that those who pay are deemed to be paid, or those who do not pay, and those receiving free treatment are actually beneficiaries of those who pay. See, under the Consumer Protection Act, the consumer is defined as a person who has paid consideration for services, etc., and also beneficiary of services. But when it comes to beneficiary of services, the definition does not say that an identified beneficiary of service, right? So it just says beneficiary of. If the words used under the Act are identified beneficiary of service, then the interpretation of the statute would mean that the person would have, if a person is identified, then he is, all others are excluded. But since the word identified beneficiary is not used, the interpretation of the term has been held to include those who receive these services, so long as there is some other category of patient who is receiving. In a recent judgment of the Supreme Court, the interesting question that was argued before the court was: suppose the doctor who treats me is paid by the government, and even if there are no free services at all, and even if the hospital services are completely free, am I not a beneficiary because the government pays the doctor? That argument was shot down by the Supreme Court, And the Supreme Court held that just because the government pays salary to a doctor, you would not come within the definition of visa. So that is where we stand on a very, very important segment of cases, which is the case of medical service. One other set of cases that have come before court are matters relating to the railways. The Supreme Court has held and continues to hold that a general manager versus Southeastern Railways versus Anand Prasad Sinha, that the railway administration is providing transport facilities to the public for consideration paid by them by way of fare levied for the ticket. It is one of the largest public utility undertakings in the country, intended to render service to the public by providing transportation by rail through its large network extending from Kanyakumari in south to Jammu in the north. Therefore, there is no hesitation to hold that the passengers traveling by trains on payment of stipulated fare charged for the ticket as consumer is a consumer under the protection as defined under the consumer protection. Why these cases are important once again is because under the acts that apply, there is provision for other redressal avenue. But because there is a redressal avenue, it does not mean that the consumers are excluded from the purview of the Consumer Protection Act. The other class of cases which have engaged the attention of the consumer courts are matters relating to deficiencies in insurance. We had a separate session on that, and I'm sure there is a lot of knowledge that have been shared about how insurance claims have been dealt with. There again, there is a large class of claims that are produced before the consumer courts on with regard to deficiency in service, with regard to insurance services, and the courts have held that the consumer courts will have jurisdiction in respect of these matters. One of the very first cases that was taken up was Umidulal Agarwal versus United India Insurance Company Limited, where after going through the provisions of the Act, the court held that having regard to the philosophy of the Consumer Protection Act and its avowed object of providing cheap and speedy redressal to consumers affected by the failure of the part of the person providing service for consideration, the settlement of insurance claims will be covered by the expression insurance occurring in Section 2 of the Act. The term consumer includes not only the person who hires or avails services for consideration, but also the beneficiary of such services, the consent of the person who hires or avails of service for consideration. This rule was invoked to say that a nominee of the insurance policy is a consumer under the Act, and a nominee being a person appointed by the policy holder. Appointed by the policy holder of the insurance to whom the payment secured by the policy is made in the event of his death is a beneficiary entitled to avail the services with the approval of the person who hired services for consultation and is thus a consumer person under the Consumer Protection Act, which is the Divisional Manager Life Insurance Corporation versus Uma Devi, 1991 CPJ 516520. Now, here again, an interesting argument was taken that the insurance policy actually was availed by a person who is no longer alive. And the definition of consumer, since he is not the person who has opted the consideration.
Your voice is not clear, Mr. Rajan.
The nominee to the policy cannot be considered. So this argument was shot down by the consumer court, by the National Commission, and it was held that a nominee of a policy will also be entitled to the coverage under the provisions of the Act. Now, there is another interesting argument. Insurance companies became complainants under the Act. Right? Why did they do that? When the insurance company compensating the consignor for loss of goods took letter of subrogation and then filed a consumer complaint for recovery of amount against the carrier of goods. What happens is the carrier of goods insures the complainant, the consumer insures the goods, and the carrier of the goods is responsible for negligence, and the goods are lost. Now, the consumer cannot file a complaint against the carrier because it will amount to a commercial transaction. So, what happened in a case before the Supreme Court was the insurance company settled the claim of the consumer, and it said that once I settle the claim of the consumer, I step into the shoes of the consumer, and therefore I am entitled to file the claim against the insurance company. And Savani versus Textile Limited, when the insurance company compensating consignor of loss of goods took letter of subrogation and filed consumer complaint for recovery of goods.
Excuse me, sir. You're not able to listen carefully, sir. Your voice is
and consumer complaint by the insurance company is not maintained. So this was an interesting argument taken by an insurance company.
Mr. Raja?
I am stepping into the shoes of the consumer, and at that point of time, as I told you, in respect of insurance, in respect of commercial services, the service, the definition of consumer would still be available. So that was invoked by the insurance company to say that it is entitled to file a claim before the consumer court, and the Supreme Court turned down that argument. There is again a large number of cases that come under the education sector, and the question is whether these complaints are maintainable before consumer courts. Now, the Supreme Court, this will again depend largely on the facts and circumstances of every matter. Because in a large number of cases, the Supreme Court has held that where a complaint is filed relating to matters that are purely administrative, then the consumer complaint will lie. But where this, it does, for example, you go to a college, and some college says that we will ensure that every student passes the examination. So this is all part of business advertising. Everybody will say that their product is good. Nobody is going to say that my services or product is bad. So when you go with a promise like that, and that promise does not rectify, the question is whether that service will come within the. So where it relates to matters which involve some exertion on your part also, because an educational institution cannot wave a wand and suddenly get you to pass an exam. So where it involves some exertion on the part of the consumer also, and the institution, it is not in the nature of administrative function, then the courts have held that the door of the consumer courts will always be open in respect of these complaints. But where it does not, involve anything more than a simple failure of administrative function, then the courts have said the doors of the consumer court will be open even in the education sector. in Odisha Summer, 1991 National Commission, but much of it continued. The National Commission heard, word includes does not limit the operational paramount of the Act. Examination and publication of service may give benefit to a person who appears at the examination and becomes successful for rendering the service. The opposite party charges fees can be said to be hiring of service to such a service. It is not personal service. University Statute 7512 also says that the duty of the university to conduct examination properly. Accordingly, it empowers the syndicate to conduct examination and publish results, and therefore the same falls within the definition of service. So you will largely have to decide this case on the facts and circumstances that exist in every case, and it is very, very difficult to apply something that is not a uniform rule cannot be applied. But in Bihar School Examination Board versus Suresh Prasad Singha 2009, the Supreme Court held that the board is not a service provider and a student who takes examination is not a consumer, and consequently the complaint under the Consumer Protection Act will not be maintainable against the board. So here the distinction is, while the earlier one was against the college, this was against the examination board itself. And therefore the court held that this will not constitute a complaint to be filed under the provisions of the Consumer Protection Act. So the larger concept which the Supreme Court held in Tilak Raj versus Chandigarh and Haryana school education is the legislature deliberately cast the net very wide to bring its ambit to services of any district when rendered for a consideration, barring those under a contract of personal service. Now, I have taken you through generally what is the definition of a consumer and how it has been applied to various classes. Some of the interesting cases which have caused some confusion is when agricultural seeds were purchased for agricultural purpose, whether that would amount to a commercial purpose. And the Supreme Court held, the National Commission held to interpret some National Seeds Corporation was Supreme Court held that the seeds were purchased by the complainant for agricultural purposes and not for commercial purpose, and therefore the consumer court has used the complaint filed by the complainant, and that there was deficiency in that. So this is an interesting question because here is a case where seeds were purchased for agricultural operations. Ultimately, the product of the agricultural operation is going to be sold for commercial activity, and it is going to be sold for commercial purpose. So the question is whether this would come within the definition of a commercial purpose, and whether strictly applying the strict interpretation provision of interpretation of statute, the court should have ordinarily held that this is a matter which is outside the purview of the Act. But if you take the harmonious construction and the purposive interpretation, it is obvious that the purpose of the Consumer Protection Act is to ensure a free and fair trade. And since it's a beneficial provision, anything that excludes the operation of the Act must be construed very, very strictly. And that is what we call the some example where courts have held that a particular purchase is for a commercial purpose. Power generator to run expellers in an oil mill, molding machine in a plasticware manufacturing industry, air pollution control system in an ultra blue producing industry, photo setting machine in a printing press, oxygen plant in a hospital, purchase of a vehicle by a taxi service agency as against purchase by, let us assume that there is a poor man who thinks that he should buy a taxi and use it to eke out a living, those cases have been held to be uh, one of deficiency in service. So, as I said earlier, much of it yes comes within the purview of the Consumer Protection Act. Even an organization which is rendering service of consideration and is functioning on a non-profit, non-loss basis is totally relevant when the service promised to be rendered to the complainant was not considered. So let us assume that there is a non-profit organization which is levying some charges for the service that it performs. The fact that the organization itself is a non-profit organization will not enable the opposite party to plead that it is outside the purview of the Consumer Protection Act. So these are the five distinctions that have been drawn in mind by the National Commission and the consumer courts in arriving at questions of who is a consumer deficiency, consumer dispute, deficiency in services, defects in goods, what is a consumer dispute, and what is a commercial purpose, what is purpose for earning somebody's livelihood. These are the norms. Ultimately, the courts have uniformly held. What is negligence? As I said, there is defect in goods, there is deficiency in service. But even the definition of deficiency in service, that deficiency in service must arise out of negligence. For example, if you book a ticket in a flight and the flight is to leave at 10 o'clock and the flight leaves only at 4 hours later, is there a deficiency in service? Yes, there is a deficiency. But you can't rush to court because the flight has been delayed by 4 hours. You can only go to court if that deficiency in service is out of negligence. And if the airlines, for example, there is a storm, there is some big ruckus, there is some warlike conditions that have suddenly erupted, then obviously the flight will not be on time and it will not be possible to operate the flight on time. So there is this very fine distinction that has to be appreciated, that it is just not defect in goods or deficiency in services. The deficiency in services at least must arise on account of negligence. As far as defects in goods also is concerned, it must be on account of some act which the opposite party had control over. It must not be on account of certain facts that the opposite party did not have control over. If we can establish that this happened on account of factors beyond the control, because one thing please understand, since the provisions of the Consumer Protection Act are to be in addition to and not in derogation, some principles of the Consumer Contract Act will also apply. Frustration of contract, mistake, all this will obviously apply unless any statutory exceptions have been made under the provisions of the Consumer Protection. You today have the Unfair Terms of Contract Act, of course, it's the State Commission which have been, that is a huge power that has been given to consumer courts, that they can even hold the provisions of a particular contract to be unreasonable and unconscionable. This existed in England long time back. I remember 15 years back, I even presented a paper on how we must enact a similar act here in India. But thankfully now it has been introduced as a part of the Consumer Protection Act. In England also, it is only a consumer where the bargaining power between two parties is not equal. One party can invoke the argument that it is an unfair contract, and then the court can hold that it's unfair. So many organizations are now going to face the prospect of some contract, because we argued some matters against builders before Justice Kagar, when he was the first president of the State Commission. He said that I will hold all these terms to be contracts in terror. There is a concept of contract in terror, where you can't say that the booking charge for a flat is 10 lakhs, but if you fail to pay the next installment within 2 days, I will completely appropriate this 10 lakhs. Those are really contracts in terror, and you can't have such contracts in consumer contracts, and that is because there will be always there is a always the problem of the printed form contract and consumer transactions. Today, especially when you buy online, you have what is called click and wrap terms. That is, you will be asked to click on the I agree to the terms and conditions. Most of us will not even read that, and we will click on it. At a later point of time, can those conditions be pleaded against us? It is to empower consumers against such click and wrap on types of contracts. You have the unfair terms of contract concept introduced under the Consumer Protection Act. I don't think any case has been decided yet, but that will be an interesting arena for the consumer courts to sort of ensure that there is a level playing field between the consumer and the provider of goods and services. So, thank you all for being with me patiently, and we'll be quite glad to answer any questions we have.
Thank you, Mr. Raja. So now we move on to the Q&A session. So if there are any questions, please raise your hands and we can take one by one. So there is a question from the District Commission Nagarkoil.
Can you hear me?
Yes, sir.
Yes, sir. Good evening, Mr. Raja, sir. Thanks for your wonderful speech for the past 3 hours. It's very tired also. My questions are, I think it's echoing. Is it clear? Am I audible?
Yes, yes. Please go ahead. I don't
Number
know.
one is, see, there are after judgments, the warrants are pending in the consumer commissions in a large manner. After judgments, the years together, the orders are not carried out. The very purpose is defeated. So, what you would be the suggestion for this warrant pending issues? Because the consumers is not able to get.
1 second, I think he's not here.
Yeah, I'm here. Yeah, tell me.
Oh, okay. Thank you. Yeah.
Please
Yeah.
repeat the question. I wasn't able to.
Yeah, please repeat the questions.
I have to repeat.
Please repeat.
Okay. Sir, this is regarding the warrant pending issues, sir. In the all commissions, the warrant pendings are very much in a large manner. After getting the orders, they was not executed. The consumers are not benefited. So that is my question. And another question is, I'll finish within 2 minutes. Another question is, whether the PATA transfer issues in the paragraph CPR. Number 2. Number 3.
Can you speak a little louder? I can't. Can you speak a little louder? Can you speak a little louder?
Yes, sir. Yes, sir. Can you hear me, please?
Yeah.
Can we understand the first question? This is regarding the warrant pending issue.
A warrant is issued.
So it's about execution of orders.
The member wants to emphasize is, am I audible?
Yes, sir.
I'm the president here. What the member wants to know is, what is the solution insofar as the cases where warrants have been issued and they have not been executed by the concerned police? Warrant is issued in EA stage. After the order has been passed, the complainant file execution petitions before the concerned district forums. These execution petitions, the warrant is not executed. Once the warrant, after the issuance of the warrant, they are not being executed. So there is some, a lot of cases are pending. I think it will be so in other forums also. What could be the solution for this issue? Because the consumers are not getting the fruits of the order.
See, there is earlier a reported judgment which said that the provisions of section 72 already vest the powers of a first-class judicial magistrate on the consumer court. So no further notification or direction from the state government is necessary. There is already, you have already been issued the provision under an act of parliament. So no further direction is necessary. But if you have So there is nothing to be done, either executive or legislative, from the legislative side. But what if you have problems, then it is advisable for the state commission to have a meeting with the state DGP and to ensure that the warrants that are issued by the district forums are, this is what Justice Khadar also did. There was a problem and the state commission orders and district forums were not being given effective. He held a meeting with the police to tell them these are our problems. Thereafter, they started executing. So I think it is necessary to bring your problems to the attention of the state commission. I'm sure the state commission will organize a meeting with the police to resolve this and ensure that these are being implemented.
Very well, sir. Very well, sir. Thanks a lot, sir. Once again, sir. Not to questions further.
There are two issues. The Pata transfer issue and also the education. Whether this is under the purview of CPA, whether because the different commissions are pronouncing different orders. So kindly enlighten. Thank you.
You will only be bound.
சார் பேசுறது கேட்கவே மாட்டுது மேம். கொஞ்சம் அவரோட வாய்ஸ் கொஞ்சம் கிளாரிட்டி பண்ண சொல்லுங்க மேம். நல்லா சொல்றாரு.
Yeah, ma'am. Sir, we are not able to hear you.
Yeah, 1 minute.
Yeah.
Just give me a minute.
Yes.
Sir. See, can you hear me? Can you hear me?
Yes.
So each district forum will only be bound by what the state commission of that particular state rules and the judgment of the National Commission and the Supreme Court. You are really not bound except as some sort of a recommendatory judgment for you to consider. You are not bound by the orders of other commissions.
Yes.
Within the state, if there is a problem, there is an earlier judgment, there is a subsequent judgment. You will have to go by usually the later judgment. So that is the judgment, that is the interpretation, that is the manner in which the Supreme Court has even interpreted powers of the courts, and that is the process that will apply.
Yes. Thanks a lot, sir. Thank you so much, sir. Thank you so much.
சார்
Yes, sir.
செக்ஷன் 38 எஃப் கொஞ்சம் எக்ஸ்பிளைன் பண்றீங்களா சார்?
Section 38 is very clear in the order in which the complaint must be received and what has to be done. But what exactly is your problem? See, Section 38 vests the power of a civil court in respect of certain provisions on the consumer code. What has to be borne in mind is that this is a very summary procedure, and the complaints that are filed before the court have to be dealt with in a summary manner. There is an attempt under the 2019 Act to also push it towards a time-bound proceeding. So all these have to be borne in mind. That is why, unlike the CPC, which is in several orders and several sections, the entire manner in which the consumer complaint has to be disposed is in one section, 38. That's all. Therefore, you must understand that the attempt here is to simplify. Obviously, there will be opposite parties who will try to complicate issues, but it is the power of the court to ensure that maximum benefit flows to the consumer by the administration of this act, and it is done in a time-bound and a simple manner.
Good evening,
Sir,
sir. One small regarding the education, நீங்க இப்போ elucidate பண்ணீங்க, whether student he comes under the purview of consumer.
Yes, students will come, but as I said, that is a very simple answer. The
Yes,
more
sir.
complicated part is student is coming with what complaint? Suppose he comes with a complaint that
Affiliation,
says,
regarding affiliations, recognition affiliation of the university.
yes, definitely that will come.
Okay.
But that once again, whether there is any negligence part of it will depend upon the facts and circumstances of each case.
Sir, one
Sir,
more
yeah.
question.
Audible, sir.
Yes.
Yes, this is member from Vilupuram. Sir,
Yes.
நீங்க வந்து பேசும்போது சாவின் ஃபங்க்ஷன்ஸ் வந்து கன்சியூமர் ப்ரொடெக்ஷன் ஆக்ட்லேருந்து எக்ஸ்க்ளூட் பண்ணிட்டு அந்த மாதிரி சொன்னீங்க. பட் ஆக்டை படித்து பார்த்தா இந்த மாதிரி சாவரின் ஃபங்க்ஷன்ஸ் எக்ஸ்க்ளூட் பண்ணதா எந்த விதமான எக்ஸ்பிரஸ் ப்ரொவிஷனுமே இல்லை. எப்படி ஹவு வி கன்ஸ்ட்ரூ சார்?
அதுதான் நான் சொன்னேன். The purpose of this presentation itself is interpretation of statutes. So interpretation, there is something called purposive construction. There is something called harmonious construction that you just can't go by the literal rule. நீங்க வந்து you are going by the literal rule. You are saying literally there is no exclusion of sovereign functions. So how are sovereign functions to be excluded? The answer to that is purposive construction and the various judgments on the SP Goel case எல்லாம் சொன்னேன் இல்லையா? Those are the cases where the Supreme Court has gone into this and said that sovereign functions are excluded. That is the basis on which we are saying this. An interpretation of a statute goes beyond what the mere words of a statute say. And that has to be gathered from various judgments of the High Courts, Supreme Courts, National Commission, State Commission. And there is an interpretation by the Supreme Court which has said that it will, sovereign functions are excluded. You are right. There is nothing in the act specifically which excludes that, but we have to go by Supreme Court.
Sir, one more doubt, sir.
Yes.
Sir, one more doubt.
Yes.
Sir, a person filed a petition against the some person. அதாவது புகார்தாரர் என்ன கேட்கிறாருன்னா, ஓபி வந்து 5 கோடி எனக்கு நஷ்டீடு கொடுக்கணும்னு கேட்கிறாரு.
சரி.
நான் என்ன சொல்றேன்னா, நம்ம கோர்ட்டுக்கு வந்து மொத்தமே 50 லட்சம் தான் நமக்கு ஜூரிஸ்டிக்ஷனே இருக்கு. அப்படி இருக்குமே நீ எப்படி 5 கோடி கேட்கலாம் அப்படின்னு சொல்லிட்டு எனக்கு ஜூரிஸ்டிக்ஷன் இல்லைன்னு சொல்லிட்டு ரிட்டர்ன் போடுறோம். அதுல ஒரு சைட்டேஷன்ல வந்து கன்சிடரேஷன் தான் பார்க்கணும்ன்றாங்க.
ஆமா, இப்ப லேட்டஸ்ட் 2019 அமெண்ட்மெண்ட்டுக்கு அப்புறம் கன்சிடரேஷன் தான் பார்க்கணும். அதுக்கு முன்னாடி நீங்க பிரேயர் பார்க்கணும். இப்ப வந்து கன்சிடரேஷன் தான் பார்க்கணும்.
இப்ப ஜூரி டிஸ்ட்ரிக்ட் கமிஷனுக்கு ஜூரிஸ்டிக்ஷன் எவ்வளவு சார் பெக்குனரி?
எதுக்கு?
டிஸ்ட்ரிக்ட் கமிஷனுக்கு பெக்குனரி ஜூரிஸ்டிக்ஷன் எவ்வளவு லிமிட் இருந்தா நம்ம பெட்டிஷன் எடுக்கலாம், எடுக்க கூடாது?
1 crore கீழ இருந்ததுன்னா நீங்க எடுக்கலாம். 1 crore and 1 crore கீழ இருந்தது
சார். Sir, not clearly. Audio is not clear.
1 crore கீழ இருந்ததுன்னா நீங்க எடுக்கலாம். 1 crore அவன் கன்சிடரேஷன்
பாலு சொல்லுங்க
சார். இப்போ நமக்கு பெக்குனரி ஜூரிஸ்டிக்ஷன் பொறுத்த வரைக்கும் டிஸ்ட்ரிக்ட் கமிஷன் எவ்வளவு வரைக்கும் அவங்க கேட்கலாம், நம்ம எவ்வளவு வரைக்கும் கொடுக்கலாம்?
நீங்க வந்து
சொல்லுங்க சார்.
எவ்வளவு கொடுக்கலாங்கிறது ஜூரிஸ்டிக்ஷனை டிட்டர்மின் பண்ணாது. அவன் சர்வீஸ்க்கோ என்ன பே பண்ணிருக்காங்கிறது தான் சர்வீஸ் டெஃபினிஷன் டிட்டர்மின் பண்ணும். அவன் வந்து 1000 ரூபாய் பே பண்ணிருக்கான், ஆனா எனக்கு வேணுங்கிற ஈடு 1.5 கோடின்னு கேட்டான்னா அதனால நீங்க கம்ப்ளைண்ட்டை இப்ப இருக்கிற சட்டத்துக்கு கீழே டிஸ்மிஸ் பண்ண முடியாது. 2019 முன்னாடி நீங்க பண்ணலாம்.
இல்ல நான் டேக்கன் ஆன் ஃபைலுக்கே கேக்குறேன்.
Taken on file, you have to see what he says about what is the consideration that he has paid for services. அது எவ்வளவுன்னு கன்சூமர் கம்ப்ளைண்ட்ல கொடுக்கணும். அது கொடுக்கலன்னா நீங்க ரிட்டர்ன் பண்ணலாம். நீ வந்து சர்வீஸ்க்கு நீ என்ன சர்வீஸ்க்கோ நீ எவ்வளவு பே பண்ணிருக்க, நீ பே போடல, நீ அதை போட்டாதான் எனக்கு தெரியும் ஜூரிஸ்டிக்ஷன் இருக்கான்னு எனக்கு தெரியும் அப்படின்னு சொல்லி நீங்க கன்சூமர் கம்ப்ளைண்ட்டை ரிட்டர்ன் பண்ணலாம்.
அதுதான் அவர் கேக்குறாரு. 1 crore உள்ள இருந்தா எடுத்துக்கலாமா, ஃபைல் பண்ண நம்பர் பண்ணலாமான்னு கேக்குறாரு.
நான் பதில் சொல்றேன். 1 crore அவன் கேட்கறது இஸ் நாட் டெட்டர்மினேட்டிவ். வாட் இஸ் டெட்டர்மினேட்டிவ் இஸ் அவன் சர்வீசஸ்க்கோ குட்ஸுக்கோ எவ்வளவு பே பண்ணிருக்கேன்னு சொல்றாங்கிறது தான் டெட்டர்மினேட்டிவ். நான் 1000 ரூபாய் நான் ஸ்பெண்ட் பண்ணேன், ஆனா அதனால எதையோ சாப்பிட்டேன், எனக்கு ஹாஸ்பிட்டல் அட்மிட் ஆகி நான் 1.5 கோடி ரூபாய்க்கு எனக்கு பில்லு வந்துருது அப்படின்னா அவன் 1000 ரூபாய் ஸ்பெண்ட் பண்ணிருக்காங்கிறதுனால டிஸ்ட்ரிக்ட் ஃபோரம் will now have jurisdiction. நீங்க அதை டிசைட் பண்ணிட்டீங்கன்னா தென் அப்கோர்ஸ் என்ன கொடுக்க போறீங்க கொடுக்க போறீங்கிறது வந்து அந்தந்த டிஸ்ட்ரிக்ட் ஃபோரமோட ரைட் இருக்கு. It will decide that on account of law. But if he says I only pay 1000 rupees, even if he asks
ஹாஸ்பிட்டல்ல அட்மிட் ஆகுறாரு, 99 லட்ச ரூபாய் பில் வந்திருக்கு, அதை வந்து கிளைம் போடுறாரு சார், இங்க அட்மிட் பண்ணி நம்பர் பண்ணலாமா, பண்ண முடியாதா?
நீங்க பண்ணலாம். You can, provided that this is what he has paid for services and goods If it is less than a crore, then you have jurisdiction. That is how the new act is. அததான் நீங்க இதை எடுத்துக்க முடியும்.
Sir, please correct me if I'm wrong, but I think it has been reduced to 50 lakhs.
50 lakhs, only 50 lakhs.
Actually, they have reduced it to 50 lakhs district commission and state. Please correct me. So first act வந்தப்போ 1 crore இருந்தது. அதுக்கு அப்புறமா further amendmentல இப்போ 50 lakhs ஆக்கிருக்காங்க. So 50 lakhs.
Actually, ma'am, it is not an amendment by way of amendment.
State commission.
National commission has issued some orders.
So whatever applied.
The act has not been amended.
What
Act has not been amended.
Every complainant per state, what is the consideration he has paid for goods and services, and that will what will determine jurisdiction. This is all I'm saying.
Yeah.
I don't know what is the correct.
Medical case சொல்லிருந்ததுல வந்து he said 99 lakhs was the bill amount. So if it were the bill amount, then I think they will have to file in the state commission.
That's right. If it is above that, it has to be filed in the state commission.
Yeah. Thank you, sir.
கோட் ஃபீ ஆக்ட் நமக்கு சிபி ஆக்டுக்கு அப்ளிகபிள் ஆகுமா சார் இல்லை ஆகாதா? கோட் ஃபீ ஆக்ட்
புரியல.
இப்போ நம்ம சிஎம்பிஸ்க்கெல்லாம் மெடிசன்ஸ் பண்ணுறாங்க இல்லைங்களா சிஎம்பிஸ்க்கு, அதில் வந்து நம்ம வந்து கோட் ஃபீ பே பண்ணணும்னு சொல்லி இன்சிஸ்ட் பண்ண முடியுமா? இல்லை கோட் ஃபீ ஆக்ட் அப்ளிகபிள் ஆகுமா ஆகாது?
I am not aware of what the rules are with regard to that.
Okay, sir.
Students consumer வருவாங்களா சார்?
Students அதான் as a general proposition, yes, will come within the provisions of the Consumer Protection Act. But
யூனிவர்சிட்டில பே பண்றோம், நடுவுல டிஸ்கண்டினியூ பண்ணிடுறோம், அத கிளைம் பண்றாங்க, அப்படி இருக்கிற ஸ்டூடண்ட்ஸ் வந்து கன்சியூமரா வருவாங்களா சார்?
அதான் சொல்றேன் நான், it will depend upon the fact, circumstances of each case and what they produce. இதுல ரெண்டு பார்ட் இருக்கு. question will come within the Consumer Protection Act. Yes, they will come with the whether there is merit in what they say, that depends upon what is produced before the court, what they are able to establish, and whether there is negligence. Negligence, as I said earlier, is something which the university ought to have done, which it has not done. For example, university is not able to hold examination because there is some directive by the government. There is no negligence on their part. He can't get anything. But where something is under the control of the university, which they have failed to do, then in respect of that, definitely a consumer complaint. That has to be decided on the facts and circumstances of each case, and I can't answer that generally. Education services will come to that.
Thank you, sir.
Sir, I want one question, sir. Sir, some of the complainant filed the examine to cross-examine the OP. It is maintainable, sir?
Oh, yes. So they can file under to examine the actual affidavit file pannale. You must give them an opportunity. You must ask them whether they want to cross-examine. If they have no cross-examination, then act on the basis of the proof affidavit. But if proof affidavit is filed, and if the other side asks for an opportunity, I don't think even an application is necessary. If the other side even orally represents that I want to cross-examine, then that opportunity must be given to them.
No, sir, they made application, sir. Made my application.
Can be allowed and they can be permitted to cross-examine.
But the chief வந்து நம்ம வந்து பாக்ஸ்ல ஏத்தி விசாரிக்கிறது இல்லையா சார்? வெறும் நம்ம பேப்பர்ல கொடுத்து
proof affidavit தானே இப்போ சிவில் கோர்ட்லயே அப்படிதானே பண்ணுவோம். proof affidavit தான் பண்றோம். சீஃப்ல பாக்ஸ்ல ஏத்தி chief examination ஒன்னு சிவில் கோர்ட்லயே போயிடுது. We only file proof affidavits.
Yes, sir. Thank you, sir.
Sir, one more question.
Section 107 கொஞ்சம் எக்ஸ்பிளைன் பண்றீங்களா சார்? இன்டர்பிரேட் பண்றீங்களா சார்? Section 107. Section 107, sir. 107, repeat.
107ல
அதுக்கு இன்டர்பிரேஷன் கொஞ்சம் கொடுக்குறீங்களா சார்?
So what your problem on section 107? What exactly is your problem? Repeal and savings. Whatever அதுல வந்து provisions of the General Clauses Act இருக்கு. Whatever the large body of case laws on this. But basically the rule is that The new act will repeal whatever has been done earlier, unless there is some notification order which has been passed under a particular provision of the act, which is not contradictory to what is in the new act. This is a complicated procedure. நான் தனியாவே ஒரு கிளாஸ் எடுக்கணும். இதை ஒரு சிம்பிளா சொல்ல முடியாது. That's why I said, if you face a problem in that, it is easier to address that particular problem. But an interpretation of that will involve Section 6 of the General Classes Act, and what is saved, what is not saved, what is a new provision, what was the earlier provision. Generally, what it means is all these act provisions will have effect, notwithstanding anything contrary contained in the act.
செக்ஷன் 72 படி பெனால்டி கிளாஸ் இருக்குது. நம்ம ஆர்டர் போட்ட பின்னாடி வந்து பார்ட்டிக்கு வந்து ஒன்று இபிக்கு போகலாம். இபிக்கு போகாமல் இந்த பெனால்டி கிளாஸை இன்வோக் பண்ணி அவங்கள வந்து பீனலைஸ் பண்ணுங்கன்னு சொல்லி கேட்கலாமா நம்மள்கிட்ட?
அதான் நீங்க ஆர்டர் போடும் போதே நீங்க பெனல்டி இம்போஸ் பண்ண முடியாது. there are a number of judgments on that.
after passing order ஆர்டர் பாஸ் பண்ணிடுறோம். ஓபி வந்து எக்ஸிக்யூட் பண்ண மாட்டேங்கிறாங்க ஆர்டரை. இந்த கேஸ்ல வந்து கம்ப்ளைண்ட் வந்து ஒரு ஆப்ஷன் வந்து இபி போகணும், அல்லது இன்ஸ்டெட் ஆஃப் கோயிங் ஃபார் இபி வெதர் தி கம்ப்ளைண்ட் கேன் இன்வோக் செக்ஷன் 72ல எனக்கு எக்ஸிக்யூஷன் வேணா என்ன இப்ப பீனலைஸ் பண்ணுங்க ஓபி அப்படின்னு கேட்க முடியுமா? செக்ஷன் 72 படி
71 இன்வோக் பண்ணாதுக்கு அப்புறம் தான் 72 இன்வோக் பண்ணணும்னு ஒரு சட்டமும் இல்லை. அதனால 72 டைரக்டாவே he can
அங்க இப்ப வந்து 72 இன்வோக் பண்ணா நம்மள்ட்ட வருங்களா இல்ல ஜூரிஸ்டிக்ஷன் வந்து
இல்ல உங்கள்ட்ட யார் ஆர்டர்
கோர்ட் மேஜிஸ்ட்ரேட் கோர்ட் போயிரு. ஓகே சோ வந்து அப்ப இன்ஸ்டெட் ஆஃப் இபிக்கும் போலாம், சைமல்டேனியஸ்லி 72ல பெனால்டி கிளாஸ் இன்வோக் பண்ணலாம்.
Sir, one more question from Thuthukudi. Hello.
Yes, sir.
ஒருத்தர் வந்து பிசினஸ் டெவலப்மெண்ட்டுக்காக ஓவர் டிராஃப்ட் ஃபெசிலிட்டி அவைல் பண்றாரு பேங்க்ல 50 lakhs. அப்புறம் டெஃபிஷியன்சி இன் சர்வீஸ்னு கன்சியூமர்ல வராரு. whether he is coming under consumer?
No, he will not come under consumer now. After 2002 amendment, since it is for a business purpose, it will not come. If it is not for a business purpose, then it will come.
Sir, for running his livelihood அவர டிஃபென்ஸ் எடுத்தா என்ன பண்றது சார்?
Then you have to examine it on the facts, whether he has proved that it is merely for his livelihood.
Oh, thank you.
Excuse me, sir. This is from Tiruvannamalai. We would like to know about the difference between ex parte order, declared ex parte order, and the mere ex parte. There is a confusion. In this regard. Pardon, sir. We are not able to hear you, sir, properly. Voice is not audible.
Voice.
No.
Hello?
Yeah.
Can you hear?
Yes.
Now it's clear.
Party order na vidhamana ex parte order. நீங்க வந்து you can pass an order.
It's breaking, sir. It's breaking. Not able to hear properly.
You can pass.
Sir, கேக்குதா?
You can either pass an order or you can pass an order party merits la pass பண்ணி review போட்டாங்கன்னா you will have jurisdiction to hear it. But mere ex parte order setting now on account of 2011.
Sir, I would like to ask one more question, sir.
Not audible, sir.
Yes, can I ask one question?
Yes, please.
Yes, this is relating to education. When I deliver a lecture to students, many students are asking one question. When the students pay their fees, when the teacher is not covered the syllabus and students fail, can a student file a case against the teacher? But law clearly says university people are excluded. What about the college teachers?
Sir, na minadi sonna
University teachers are excluded.
Yes, as I said earlier, it's very difficult for me to answer questions on the merits of each case. It's possible for me to say whether a complaint will lie, complaint will not lie. Basically, it can be established that there is consideration paid, services have been availed of, it is not a soft function, complaint will lie. What a consumer says before a court is a matter of application, and therefore you have to look at what is excluded, and if it is not included, court has jurisdiction. Pass on the merits of each case. It's very difficult for me to comment on the merits of the case without appreciating all the issues.
Waiter, madam. Sir, voice break is there. Can you repeat once again? Sir, voice break is there.
I'm
Merits
sorry.
of the case.
The battery is down. So let me repeat the last thing. What I'm saying is, on merit, it is difficult for me to say whether it will lie. Education service, I said earlier, it will come within the purview of the customer.
Okay.
Yes. Samantha, can we close this?
Yeah. Any other questions? Shall we close the session for now? Where are questions, Irunda? Please write to us. We can write and ask for.
Please ask to give citations, madam, please.
Yes, sir.
Yes, many citations. Ask him to give those citations.
Sure, sir. Sure. Definitely, sir.
Thank you so much for information, sir.
Those citations that you mentioned yesterday, then we can share it with the State Commission. Yeah. Thank you all.
Thank you.
Thank you, Mr.
Thank
Raja.
you, madam. Thank you.
Today.
Thank you.
Yeah. Thank you all for joining us. So we'll let us meet tomorrow. Thank you.
Thank you, ma'am.
Thank you.
Thank you. Thank you very much, sir.
Thank you.
Yeah. இதுல ஒரு 70 பேர் judicial judges, court judges. Consumer Protection Act. Only case alone is